Yes, Ms Newton.
Thank you, my Lord. I will now proceed to address the substantive issues in the appeal. And the main dispute before the Board today arises from the decision of the Court of Appeal to vary the terms of the disqualification order made by Mr Justice Morley in two ways, as your Lordships have heard this morning. First, to restrict the disqualification of the first two respondents so that they were disqualified only from acting as directors of the companies under investigation and not of any other company. And secondly, as regards Ms Allen, to set aside the disqualification order in its entirety. Before I start my submissions on the first of those, I should point out to the Board that there is a new Companies Act which is in force in Montserrat, which came into force on the 1st of April 2024. And your Lordships have that in the supplemental bundle at page 21. The relevant provision is at page 22, section 166, the disqualification order. What I propose to do is to address your Lordships in relation to the issues in the appeal which concern the previous version, but then to address your Lordships in relation to the relevance of this provision. I was somewhat surprised that it wasn't addressed in my learned friend's submissions, as she was the one who put it in the bundle, but it's obviously relevant. It certainly, as far as today is concerned, perhaps renders the issue in this appeal doubly academic in this way. First of all, the meaning of section 65 and 66 is already slightly academic as regards my clients because the period of their disqualification has indeed lapsed. And now it is doubly academic because there is a new Companies Act which is in force in Montserrat, which does not replicate exactly the provisions that were in the previous version. And in particular, there is no section 65(2), but what there is now, and it is relevant to the question that my Lord Stevens raised, is there is a criminal offence. And if we could just turn that up, perhaps. It's at page, first of all, we see at page 22 of the supplemental bundle. We see the same wording that was in the previous version. It's a slight reformulation, but it still remains at section 1661, that if on the application of the registrar, the court determines that an individual is unfit to be concerned in the management of a company, it may order that ... And importantly, that the person may not be a director of the company or in any way directly or indirectly be concerned with the management of the company. And your Lordships will see that the section goes over to page 23. There is now new subsections 6 and 7, which importantly
an offence.
Provide a criminal offence indeed.
Yeah.
And is there still an equivalent of the old section 65(2)?
No, my Lord.
There isn't.
No.
So it's got even worse in one sense.
Yeah, it is even worse in one sense. It does mean that the debate about section 65(2) is perhaps somewhat sterile, because insofar as your Lordships are giving guidance as to the meaning of these provisions going forward, it is this statute which is going to govern the matters in Montserrat and not the previous version.
But without section 65, I'm so sorry.
The offence includes management of the company.
That's right, my Lord, yes, it does. So it is a more wide-ranging provision in that it states now that a person commits an offence if, during the period for which the order is made under section 1, he acts as the director of a company or is in any way directly or indirectly concerned with management.
So it's a company there.
It's a company
there.
So without section 65(2) and looking at the offences, it's easier to think that the is just a slip of the pen in section 166, 1, the company.
Well, it is and it isn't, my Lord. I think
because it's very odd if you get disqualified from acting for Joe Bloggs Limited, so you act for Fred Limited, and then you get convicted of an offence, even though you haven't been disqualified from acting for it.
It is, my Lord, and it is an unsatisfactorily worded statute, both in its original form and in this form in my submission. And that will bring me on, I think, to my submissions in relation to the issues before the Court of Appeal, which concerned the reading of section 66 and the implications of section 65. But as your Lordship rightly, as my Lord rightly notes, it is a provision which does not track the wording. So subsection 6 does not track the wording of subsection 1. And that causes an unhappy dissonance within the wording of the statute. I thought it right to draw this to your Lordship's attention at the outset, because although I'll be making submissions about what happened in section 65 and 66, it's important for your Lordships to be aware going forward that this will be the regime that operates in Montserrat, and it's this in respect of which any guidance might be given, I think.
Well, the use of the definite article in subsection 1 and the indefinite article in subsection 6 can't be accidental.
That was going to be my next submission, my Lord, which was that this provision has obviously now survived two passings through the legislature in Montserrat, and there must be a reason why it is worded in the way that it is. It is an unhappy wording, as I say, and there is a dissonance between the two sections. But to bring myself on to the subject that I was going to address, which was what was the Court of Appeal doing as regards this wording in our case? The first point I was going to make is that I do accept that a court exercising its powers under what were Section 65 and 66 can make an order to disqualify those that it deems unfit from being a director, from holding office in any company in Montserrat. And I think that was the point that Lord Reid put at the beginning of my learned friend Miss Morgan's submissions, which was that is the extent of the power under Section 66. I accept that it is not necessarily the only effect of an order under Section 66, and I will submit that that is not what the Court of Appeal ordered in this case. Because my key submission is that the Court of Appeal was right that the lower court's order was defective, because Section 66(1) provides that the company may order that the individual may not be a director of the company, and that is quite clearly specified both in the Section 66(1) and now again in Section 1661. What the court is empowered to do on the application of a registrar is to order that without prior leave of the court, the person may not be a director of the company, i.e. the company that is under investigation. I accept that the effect of such an order may, in our case as a result of Section 65(2), be that the individual may not be a director of any company without leave of the court. But that is different from the court actually ordering that the individual may not be the director of any company. That latter point may give rise to an argument that the question of whether the individual ought to be given leave to act as a director of a different company had been considered and determined. And what I think the Court of Appeal was doing was ensuring that the order made didn't go beyond what Section 66(1) provided for. So, for example, my clients could have applied for leave to be directors of a different company under Section 66(1), and the registrar could not argue that the point was res judicata. Further, alternatively, my third submission is that it is clearly open to the Court of Appeal to make an order granting leave for the individual to be a director of a company during the period of disqualification. We can see that in subsection 66(1) and in subsection 66(4), and I think my Lord Reid referred to that provision in relation to the leave regime as meaning that Section 65(2) couldn't operate in an absolute way. That's clearly right. It's clearly expressed in the statute that there is an ability to grant leave, notwithstanding the conclusion that the court has apparently reached that an individual is unfit to be concerned in the management of a company, i.e. the one under investigation. The court can still grant leave to the individual to act in respect of another company or more generally. I would suggest that there is no reason why that leave could not be framed in a negative if the circumstances warranted, i.e. the individual has leave to be a director of any company except X, the one that has already been found to have been the subject of investigation. That is, in my submission, what the Court of Appeal has effectively done here.
The prior leave is in relation to being a director of the company.
In subsection 66(1), I agree, that is the reference to it. But if one looks at subsection 66(4), it's subsection 1664 in the new version, and in the previous version, I think it's also section 66(4), on the hearing of an application for leave under this section to be concerned with the management of a company. So there seems to be that possibility of applying under subsection 66(1) in respect of the company, and in respect of section 66(4) in respect of a company. So there seems to be a distinction drawn.
I just don't quite follow it. I thought that the ability to apply for leave was to be a director of the company. And if you were given leave to be a director of the company, then the prohibition in section 65(2) may not apply, may no longer apply.
I can certainly see that as a logical reading of the statute. What I would say is that subsection 66(4) doesn't refer back to the company. It refers again to a company, and in my submission that's a deliberate choice which is more permissive and which would entitle an individual to apply to be concerned with the management of a company other than the ones that have already been under investigation. There has to be some significance to the use of a company in subsection 4.
But 66.4 and 1664 are simply about locus standi and giving evidence. It's not a self-contained power to grant leave. Power to grant leave is entirely in 66.1 and now 1661.
I can see the logic and the force of that, my lord. I can see that subsection 66.4 and 1664 are concerned with the submissions that can be made, the evidence that can be given, and so on.
Yeah.
I can
it says
see
an
that.
application for leave under this section.
Yes.
So you ask, well, where do you find that? And the answer is subsection 1.
Well, the section is actually slightly unclear because it may well be referring, it's not clear whether it's referring to subsection 1 or subsection 4 or something else, whether it's under subsection 66 as a whole rather than on one of the specific sub-provisions there of it. I don't say that much.
Surely it must be 66 as a whole.
Yes.
Yes, but the only place you find the positive conferral of a power to grant leave is subsection 1.
And what do they do if the company, after 3 years, no longer exists? How can they apply
Yes.
without the prior leave of the court to be involved in the running of a company that no longer exists?
Yes, I can see that. And that is obviously a scenario that occurs not infrequently, perhaps, as I think was observed in exchanges earlier. It may well be the case that disqualification frequently arises in a case where the company has wound up and no longer exists. And I do recognise that the difficulty that poses for my possible interpretation of what the Court of Appeal was doing, because in this case it is right to recognise that the companies of which, with which we are concerned had indeed been wound up, and the Court of Appeal was obviously aware of that when it made the order that it did. I have to recognise that, and I don't shy away from that fact. What I do say is that the Court of Appeal was obviously concerned with the extent to which these disqualification orders should restrain the respondents from acting as directors in future, and what it decided after hearing lengthy argument and considering matters on the merits were that the disqualification order in respect of Miss Allen should be removed in its entirety, and the disqualification orders in respect of Mr Fagan and Miss Lidbetter should be limited to the companies under investigation.
There was argument on this point, was there?
There was not argument in relation to the extent to which they should be entitled to operate as directors of other companies. But what the court was very much concerned with, because it was an issue and the grounds of appeal that had been filed by my clients, was the extent to which they should be disqualified at all. Because, of course, there was an issue in relation to the terms of their the extent of their unfitness. And it has always been my client's case that there was no basis for disqualification orders to be made against any of them. And although the impression was given by my learned friend in her submissions earlier that much of these facts were agreed and there was really no dispute, actually one of the common themes of this case is that almost everything has been disputed by the respondents, and almost every point that is relied upon by the registrar is indeed in dispute, including in particular this issue as to the terms of whether they should be disqualified at all.
Were there submissions before the Court of Appeal in relation to adjusting the order of the lower court so it only referred to the company?
No, there weren't.
Yeah.
Before we leave section 166, since you rightly point out that's the one that's going to apply in the future, is one way of looking at subsection 6 that it incorporates the old 65(2), in the sense that if you've been disqualified from acting for the subject company, then it's an offence to act for any other company, except that they've cured the problem about being concerned in management not being in 65(2) by sticking it into some 1666.
Yes, my lord. I think that is, and that was my instinctive reading of this new statute. That is, as I understand it, what they have sought to do. For the purposes of today's appeal, and as far as my clients are concerned, it is slightly irrelevant because I'm mounting an argument that we need to be looking at what the Court of Appeal was doing as regards varying the order of Mr Justice Morley. But I absolutely accept the point that my lord makes as regards the future
current
conduct.
section is really invaluable.
It is.
as will be anything that your opponent wants to say in reply.
Yes.
Yeah.
How does a person know about the criminal offence he's about to commit if the order under the new 166 is that he's not to be a director of the company or any way directly or indirectly concerned with the management of the company?
Yes.
How is he supposed to know when he gets that order in his hand that if he breaches it, he's going to go to prison or whatever?
It is a difficult point, and I think one of the issues that emerged from the exchanges that the court was having with my learned friend earlier was that there appears to be quite a degree of imprecision as far as the Montserrat regime is concerned, with operating as a director as opposed to operating directly or indirectly. And one of the points I wanted to make was in relation, and it was I was going to come on to as a second defect in the order of Mr. Justice Morley, is that he uses this slightly rolled up formulation of disqualification as being unfit for the period of 4 years in Mr. Fagan's case to be concerned in the management of a company. And the question is, well what does that mean? And my learned friend's answer to that when the panel put that to her was effectively, we see this all as the same, and if you're involved in the management of a company, then you are a de facto director. In my submission, that is wholly unsatisfactory, because one needs to have clarity for exactly the reason that my Lord Stevens raises, all the more so now that there is a criminal offence in this statute, because it cannot be the case that merely conducting a low-level management responsibility that would not meet the standard of a de facto director can be encompassed and swept up within a prohibition on acting as a director, as my learned friend seeks to suggest.
But at the same, if the criminal offence is really new in 1666, that also cures the problem about de facto director, because it specifically says it's an offence to be concerned in any way of the management.
It does, and that may still be an unsatisfactory position to get to, but that seems to be a clear reading of what the statute is saying. Yes. And I don't seek to argue any differently. All I'm saying is that, in particular in the historic circumstances of this case, the order that was made by Mr. Justice Morley was particularly unhappily expressed and particularly imprecise in the way it was formulated. And I will go on to suggest that that was another reason why the Court of Appeal was quite right to vary it and to make it more precise in its ambit.
Yes.
Can I ask, do you know, or it may be that Ms. Morgan can help us on this, do you know if an individual was disqualified and under section 65(2) we're told that the individual may not be a director of any company, was there any sanction if somebody breached that?
I'm not aware. I'm afraid I'm not able to assist with that point, and it may be that my learned friend is able to.
I mean, now we know now it's a criminal offence, but
I am aware that my clients have been seeking, and it is a great frustration on their part, that they would like to be able to continue doing business and to be involved in the management of companies, but they have been prevented from doing that, I think perhaps on a part of the registrar refusing to allow them to be appointed or refusing to allow companies that they appeared to be associated with to be registered or to conduct business. And that is a particularly unsatisfactory state of affairs in circumstances where, as I say, the order of Mr. Justice Morley was not clear and was unhappily worded. But in any event, the Court of Appeal has clarified that, and in my submission it rightly clarified that, because what it did was it cut down the order of Mr. Justice Morley so that it was firmly within the bounds of what was in it possible to order under section 65 and 66 of the previous Act.
So you say that the order made by the Court of Appeal disqualified, leaving aside
Ms. Allen?
Yeah, leaving aside her, but disqualified the other two and qualified the effect of 65(2) by sort of giving leave to act for any other company.
Yes, it was framing the order in a negative. It was saying you shall not act as directors of these companies, the companies under investigation, the three companies that are named. And it was implicit in that limiting of the order that it was giving leave to act as a director of other companies.
Okay.
Just, could you help me in relation to the stay that's been imposed? So
yes.
The judge disqualified And was that order then stayed, so the disqualification didn't come into effect?
I think it was the other way around, that the judge disqualified, the Court of Appeal then set aside and varied that order, set aside in respect of Ms Allen, varied in respect of Mr Fagan and Ms Lidbetter, but it stayed the effect of its order,
So there was no stay between the High Court and the
That's
Court
right.
of Appeal?
As I understand it, that's correct. I'm sure I'll be correct if I'm wrong, but that's my understanding, is that the stay came in at the Court of Appeal stage and not before.
So during that period of time when the order was stayed, they were at liberty to be directors of companies?
Yeah, no, I think it's the other way around, isn't it? I think during the period that the order was stayed, they were not at liberty to be directors
So the
of
Court of Appeal,
companies.
did they stay the order of the High
They
Court
stayed their
judge?
own order.
They stayed their own order?
Yes.
Yeah, okay.
I wonder if I might address the defects that I alluded to already, which was in relation to the indirect and direct involvement in the management of a company. This is, if we could turn up perhaps page 456 of the bundle, we go back to the wording of Mr Justice Morley's judgment. Your Lordships have already noted in exchanges with my learned friend that the order that Mr Justice Morley made at paragraph 21A, which is the key wording that he then repeats in subsections B, C and D, he says Mr Fagan is disqualified on Montserrat as a director of any company for 4 years as being unfit to be concerned either directly or indirectly with the management of a company incorporated within Montserrat for that period. I think, as my Lord Burrows observed, that is a slightly obliquely worded provision, because there may be a question as to whether Mr Justice Morley was ordering that, as well as being disqualified as being a director, the respondents were also unfit and therefore disqualified from being concerned directly and indirectly with the management of a company in Montserrat for that period. And my central submission on this point is that insofar as he was making an order restricting them from being directly or indirectly involved in the management of a company on Montserrat, he was exceeding what was permissible under the scope of Section 65 and 66 of the Montserrat Companies Act, and the Court of Appeal was right to vary that order and to restrict it in the way that it did. It may well be that Mr Justice Morley had in mind the English provisions, because under subsection 1.1 of the Company Disqualification Act that applies in this country, it is right that a disqualification order disqualifies a director both from being director and from being concerned directly or indirectly from the management of a company. Yeah. And it may be that that is what the judge had in mind. But if we go back to the wording of subsection 66.1 and 60 in particular at page 3928, we can see that the order that is open to the court to make under subsection 66 is only that the individual may not be a director of the company or in any way directly or indirectly be concerned with the management of the company for such period. And as I think your Lordship's already noted in the exchanges with my learned friend, there is no wording in subsection 65.2 that purports to extend the effect of that section, whatever it is, to prevent an individual from being involved directly or indirectly with the management of a company.
But in relation to the Section 66 order, shouldn't the Court of Appeal's amended order have also picked up the management of the company aspect? We just talked about directors.
That's right, and I think what they were rightly doing was that they were only restricting Mr Fagan and Mr Lidbetter Ms Lidbetter from acting as directors. They were not purporting to make any order in relation to their ability to act directly or indirectly as managers of the company.
Well, why not? I mean, the judge had found that.
I think that if I'll just bring up the decision of the Court of Appeal.
Page 92.
Yes.
And they didn't make an order either? This is the order, is it?
As I understand it, this is the order. They did vary the order, limiting it to the wording that they did, which was that they may not be directors of Montebaco, Emerald Metal and 888. And we can see, relevantly for present purposes, paragraph 81 just above that order at paragraph 82.
And taking that literally, the Court of Appeal is actually allowing them to be concerned in the management even of those three companies.
Yes, I can see why your lordship say that. It is.
Do you submit that that's possible under section 66(1), or is it just a single order that you can make, which has both the director effect and the management effect? Point we put to your opponent.
Yes, I think what section 66 is doing, it is entitling the court. It says the court may order that he may not be a director of the company or in any way directly or indirectly be concerned with the management. And what the Court of Appeal was doing was saying that in respect of these individuals, we order that they may not be directors of the companies. They did not go so far as to make an order in respect of direct or indirect management, whether of those companies or more widely. And it may be that that's through oversight. The point I wanted to draw to your lordship's attention was paragraph 81, just above that, which refers back to the previous discussion of the Court of Appeal in relation to the various errors that they had found Mr. Justice Morley had fallen into, which included the weight he had attached to the inspector's report, the application of the test, in particular as regards Ms. Allen. And 81, particularly, and this is relevant for Mr. Fagan and Ms. Lidbetter, who remained disqualified pursuant to this order, said, notwithstanding those errors, the learned judge did find there was an element of dishonesty in their dealings. There was ample evidence on which he could have made such a finding. In the circumstances, his decision to disqualify them will not lead to any miscarriage of justice, so long as their disqualification is restricted to. That, I submit, was a decision on the merits that the Court of Appeal was making in respect of Mr. Fagan and Ms. Lidbetter. And it is one that the respondents asked the court to uphold on this appeal.
Back to section 66(1).
How do you do it?
You really don't need to make an order that he may not be a director of the company, because if you make an order that he's not to be directly or indirectly concerned with the management of the company, that would cover a director.
That would cover it, yes, I accept that. But that is not the terms of the order that the Court of Appeal put forward at paragraph 82(1). They said in terms that they may not be directors of the three companies. And I do understand the concern about the way in which that is worded and in light of the wording of section 66. I don't know that I can say much more about it at this stage. I wanted to turn next to the setting aside of disqualification as regards Ms. Allen, unless your lordships have any further questions in relation to the 66(5) and 66 points. This is the separate issue that arises in relation to Ms. Allen, which was whether the Court of Appeal was right on the merits to set aside her disqualification in its entirety.
Yeah.
My submission is that it was right to do so, and there's no basis for this court to interfere with that judgment on the merits as regards Ms. Allen. This is, of course, a separate point to the extent of the director's disqualification orders as regards Mr. Fagan and Ms. Lidbetter. And so it is the respondent's position that the registrar bears a heavy burden of proof here to persuade the court that it ought to interfere with the judgment that the Court of Appeal substituted, having considered the approach of Mr. Justice Morley, and there's no reason for this court to interfere with that judgment on the merits as regards Ms. Allen. It's particularly notable when one goes through the proceedings below that Mr. Justice Morley, at first instance, was clearly struggling with the test that he was to apply and the relevance of the authorities to the application of that test. And I'd like to turn back to the transcript of the disqualification hearing at page 474, because it is useful to see how it was that the first instance judge came to the conclusions he did and reached the conclusion he did in respect to Ms. Allen. You'll also see at the bottom of page 474, the court asks my learned friend Ms. Morgan, what's the test for unfitness then? She says you have to be satisfied on the balance of probabilities the facts we've alleged exist, and you have to be satisfied that these facts will make them unfit to be directors. And they have an exchange about the meaning of that and the burden of proof.
Well, Ms. Morgan's reply was spot on, wasn't it?
Well, it was spot on in this sense. It was spot on as a summary of the test, i.e. it's a test of balance of probabilities, and indeed one does have to be satisfied that the facts will make them unfit to be directors. The issue that I would draw to the court's attention as regards this exchange, which continues on, is that as we then see, if we go down to page 476, the court is asking specifically what he does in a case in the absence of an intent to defraud. And he specifically says at the top of page 476, is there anything in the Swan decision that tells me what sufficient serious is? He refers to some dicta in the Swan decision in relation to Mr. Swan not said to be acting fraudulent, leading to commercially improper practice. That would amount to some form of unfitness. It's wider than that, he says, but I'm just looking for something to give me some guidance on the expression of unfitness. And my learned friend refers him to Companies Act section 96, which contains the director's duties.
Don't we just have a look at the judgment?
Well, the reason I say that, the reason I take the court back to this, and I appreciate it may be somewhat laborious to go back through the transcript, but what is not said when the court is desperately asking for some guidance as to the standard is that if it is incompetence which is an issue and not dishonesty, then one is in the territory of the Bearings decision that we were looking at earlier, which emphasises that it's not mere incompetence that will suffice to warrant the serious remedy of a director's disqualification order, but one needs incompetence of a high degree, as Mr. Justice Jonathan Parker put it, and that was expressed in his decision, and this is in the bundle. We don't necessarily need to turn back to Bearings, but it's at page 4298, and in particular at page 4348 of the judgment, I think at paragraph A7, Mr. Justice Jonathan Parker referred to the various expressions that have been used by the courts in this connection, including total incompetence, incompetence in a very marked degree, really gross incompetence. Whatever words one chooses to use, the substantive point is that the burden of proof in establishing unfitness based on incompetence is a heavy one. That was what the judge was crying out for at first instance, and he didn't get it. It's not surprising, therefore, that when one tracks through to his judgment at paragraph 18 on page 455, he refers to the Swan decision, which does, for the record, cite the Bearings decision, but he doesn't go into that. And at paragraph 18, he simply says, reflecting on Swan, Etherton J noted, when considering disqualification periods, there is a difference between incompetence and dishonesty. What he wasn't doing there was drawing out the importance of that distinction when one is considering the matter of liability in relation to a disqualification order, i.e. has the threshold been crossed, that it makes it appropriate at all to order disqualification. He seemed to be opining that the Swan decision only brought that question into the mix when one was considering the disqualification period that was appropriate. And I say that was an error in his approach, which rightly troubled the Court of Appeal, and which they addressed at some length in their judgment, and then put right in finding, in particular in relation to Ms. Allen, that there had been no finding of dishonesty, and therefore that the judge had been plainly wrong to visit disqualification on her. That's at paragraph 78 at page 91 of the bundle. But that is where things stand as regards Ms. Allen as we stand here today. Her disqualification was set aside completely, and it's for my learned friend to persuade the court that there is an error in the approach of the Court of Appeal that warrants the interference with with that decision. And I suggest that threshold has not been crossed.
Didn't the judge also find that Montebacco was wrong abysmally, the accounts were wholly inadequate, grossly misrepresenting the position of the company, written documentation was lacking in detail, there were irregularities in convening and recording meetings, she acted as in-house counsel, though unqualified, and the documentation was scant. And she also stripped the brothers of their shares in 2018 on an illogical basis. Wasn't that also all the findings by the judge?
But those were findings at first instance, and those matters were obviously before the Court of Appeal as well. Okay. And it's the Court of Appeal's decision which stands as regards Ms. Allen's disqualification and the setting aside of that. And it may be an opportune moment to draw the Court's attention to one of the authorities that I asked to be put in the supplemental bundle, which is the decision of Das and Marchand. I'm sure that the Board doesn't need reminding of it, but it's at page 38 of the supplemental bundle.
38?
38 of the supplemental. And this is a case, of course, arising in relation to concurrent findings. Does yours have it?
But the Court of Appeal didn't itself consider the evidence, did it?
it was referred to the evidence,
Right.
and
Where in the judgment does it reflect any consideration of the underlying evidence? On this issue? They just refer to how the judge dealt with it.
they were referred expressly by my learned friend in her submissions to the specific features of the evidence that the registrar relied upon, and we see that in the transcript of the hearing at page 218 to 222. It starts at page 218, where Ms. Morgan was saying,
No, but in the judgment.
yes, I understand. The judgment itself does not recite the evidence, and that is a criticism that my learned friend makes.
Or express any conclusion of their own in relation to the evidence, is it?
Well, it expresses the conclusion, having considered in particular the findings in relation to Ms. Allen, that the judgment of the learned judge below was plainly wrong. And that is something which it did, having heard evidence, having heard submissions from my learned friend in relation to the particular features of the evidence that they relied upon as warranting Ms. Allen's disqualification. And we see that in the transcript at page 218, where Ms. Morgan was referring specifically to the evidence that they relied upon, because she made the point that she made to your lordships today, which was that we're not simply relying on the inspector's report, but there is quite a lot of other evidence in addition to that, and she rehearsed those points in relation to in front of the Court of Appeal, including in relation to some of the underlying issues that are factually disputed by my clients. So the Court of Appeal very much had the opportunity to, and was addressed in relation to the evidence that had been before the first instance judge, and heard what my learned friend said in relation to the significance of that, including in relation to the share issue, including in relation to the management of leases and so on, all of which are matters which are hotly disputed by my clients. But the conclusion of the Court of Appeal, I accept, and to accept in its judgment, was expressed as being referenced only in relation to the judge's findings in the judgment. But what I would suggest is that the Court of Appeal was plainly troubled by the fact that, as regards Ms. Allen, the judge had not been persuaded in relation to the allegation of dishonesty that was somewhat half-heartedly advanced by the registrar in relation to Ms. Allen. It wasn't part of the original case against her, and it was put very briefly in submissions by reference only to the forfeiture issue, the share issue. It wasn't one which was pressed more firmly than that.
I wonder if your submission that it's either dishonesty or incompetence misses out something in between, which is a want of probity, falling short of red in tooth and claw dishonesty, such as a grave breach of fiduciary duty and acting for self-interested reasons when a fiduciary, which of course a director always is, but without actually doing so dishonestly in the sense of covering anything up or lying about anything, and that the judge may well be thought to have had that sort of want of probity in mind in relation to Ms. Allen.
I have to accept that the test, and I was going to come on to the applicable test for unfitness, but I do commend the decision of the Court of Appeal at paragraphs 57 and 71 in this regard, which is that the legal test for unfitness in Montserrat is that extended by Lord Justice Hoffman, as he then was, in Reed Graham Building Services Limited and Liquidation. Yep. And that's at page 4559, where the court said the test was whether a director's conduct, viewed cumulatively and taking into account any extenuating circumstances, had fallen below the standards of probity and competence appropriate for persons fit to be directors of companies. So I don't seek to argue for a case that is as black and white as incompetence or dishonesty, and I recognise there will be shades of grey within that spectrum, and it is a wide-ranging formulation of the test that Lord Justice Hoffman, as he then was expounding. What I do say is that the Court of Appeal obviously considered this issue as regards Miss Allen quite carefully, because it was specifically, in her case, being asked it was being asked to look at allegations of serious dishonesty made against her, the evidence that had been put forward by the registrar at first instance in respect of those, and it came to the conclusion that the judge had got it wrong, and it was plainly wrong.
And that's the test that would have to be applied, because the judge found a lack of probity at page 453, paragraph 13b.
Yes, I have to accept that he referred to probity in that paragraph, and my learned friend relies on that, and I can't demur from that.
And the Court of Appeal shouldn't interfere with that finding of fact unless it was plainly wrong or there was no evidence to support it.
Yes, and I don't think it sought to set aside that finding of fact in relation to probity, so I don't seek to suggest that it did do that. What I suggest the Court of Appeal did is it weighed all the matters in the round, and it decided that the judge had been plainly wrong. I think I was slightly diverted. I was attempting to take your lordships to page 38 of the Das and Marchand decision, which was in relation to the approach of an appellate court in these circumstances, and it may be helpful to go back to it now. At paragraph 16, this is the super-added constraint on this appellate court, where it was noted in this practice note that the Privy Council wishes to respect factual circumstances peculiar to the country from which the case comes, especially, for example, local customs, attitudes and conditions, and the first instance and appeal court judges in those countries are very likely to be in a better position to assess such factual circumstances than is the board. The point I want to derive from that is that here the board was recognising that it is not only the first instance courts that may have an important appreciation of local sensitivities and context, but so too the local appeal court judges. And I rely on that for the purposes of my fourth submission on the point in relation to the upholding of the underlying court's decision, which is that we ought not to presume that context and policy issues that apply in Montserrat are the same as they are in England, where we have much more detailed and well-established law on directors' disqualification, and where the factors going into the balance between public protection or an interference with an individual's ability to trade may be quite different. In this regard, it might be worth pointing out that there was evidence before the judge at first instance, both from the Registrar of Companies and from the court-appointed inspector, Mr. Chris, to the effect that irregularities in company management are fairly commonplace in this part of the world. And just to make that point good, I'd turn up page 472, where the Registrar of Companies informed Mr. Justice Morley that about 40% of companies on Montserrat weren't filing their financials as required, and there were about 300 companies registered, of which about 60% could be criticised for not following all the rules. That is consistent with the evidence of Mr. Chris, also to Mr. Justice Morley at page 736 at the winding up hearing, where the judge asked, are there lots of companies which are just as badly run as this? And Mr. Chris said, there are, it's not unusual. The short point I make here is that there are local contextual issues which fall to be taken into account, and the local appellate court was well placed to consider those. There's evidence in the bundle that Montserrat is keen to encourage entrepreneurship by offering government concessions and tax exemptions to companies such as these ones in a bid to boost the local economy. And that's at page 927 for the tax exemptions and page 452 for the low rent to stimulate business. And that desire to encourage entrepreneurship is, in my submission, a relevant consideration, which the local Court of Appeal was well placed to consider when determining what the effect of breaches of companies' directors' duties or the extent of a company's director's disqualification should be. I would also point out that we have already addressed the fact that we have already had extensive submissions about the fact that the companies that were under investigation had, of course, been wound up at the time these disqualification orders were made. And so there is a degree of perhaps ineffectiveness if I am right on the terms of the order that the Court of Appeal substituted for that of Mr. Justice Morley, i.e. the respondents were only to be restricted from being directors of those companies. I think that does bring in a question of deterrence, and I'd like to just turn up an authority of page 4697, which is the judgment of Lord Wolfe in Westmid Packing Services, the Secretary of State for Trade and Industry and Griffiths. And at page 4697, there is the point arose, and it's at page 4704, the quote that I'd like to draw to the Court's attention.
I'm sorry, which page?
4704. Just at the bottom of page 4704, here the Court is quite helpfully going through some of the authorities in relation to the purpose of disqualification and the deterrent effect. And in subparagraph 3, letter J, one result of, and this is concerned with companies where it may well be the case that since since the acts which are the concern of the application for disqualification, there has been a considerable time lag, and that's the sentence starting, but there is often a considerable time lag between the conduct complained of, its discovery, and the disqualification proceedings actually coming to court. We return below to that question. One result of delay when it does occur is that there are occasions when disqualification must be ordered, even though by reason of the director's recognition of his past failings or the way he has conducted himself, he is no longer a danger to the public at all. In such cases, it is no longer necessary for the director to be kept off the road for the protection of the public, but other factors come into play in the wider interest of protecting the public, i.e. a deterrent element in relation to the director himself and a deterrent element as far as other directors are concerned. The short point I make in this regard is that this is the territory that we were in as regards my clients, because the time period certainly now has passed for their disqualification orders. They are no longer of any effect. And the Court of Appeal, when it was considering these matters, was concerned with the question of deterrence, i.e. what is the appropriate order to make for the purposes of protecting the public and the appropriate level of deterrent effect. My submission is that this is a further reason why the Court of Appeal's decision is to be upheld, because it is it is the forum best placed to make that decision and to weigh the factors in the balance that I've just been outlining, for example, the desire to stimulate business, the desire to encourage entrepreneurship, as against any desire to deter mismanagement of companies. And that, I suggest, is a local issue in respect of which it would take a high degree of irregularity for this court to interfere with it. And I suggest that degree of irregularity is not made out in these circumstances.
Why isn't the first instance judge in the local court in a very strong position to judge those local matters?
Well, as it turns out, in this case, actually, Mr. Justice Morley is not, of course, he is a local judge in Montserrat, but he is of English background. I don't seek to suggest that he wasn't well placed to judge these issues, but I do suggest that the Court of Appeal, when it regarded them, it was the local appellate court, and the burden is on my learned friend to persuade your lordships that the local appellate court, which is the current standing decision in these proceedings, got it wrong and was plainly wrong in the way it approached these matters. And I do suggest that is a difficult threshold to meet, and one which is not made out on, particularly as regards the approach to Ms. Allen, it is not made out on the facts.
Well, what should we do if we were minded to think that there were some small defects in the judge's approach, but there are also some defects in the Court of Appeal's approach, such as, for example, their attitude to the weight to be given to the inspector's report? That ends up with us having to do it ourselves, presumably.
Yes, I think the question for your lordships is whether the standing decision in this matter, which is currently that of the Court of Appeal, is so plainly wrong that it warrants interference.
Yeah, but assume we came to that conclusion,
yes.
Not necessarily on a plainly wrong basis, but taking into account some inappropriate matter or making an error of law in the
yes.
analysis, then I suppose we have to do it ourselves.
Yes.
And at that stage, it's really this, isn't it? It's the application of what the authorities show is
yes.
the relevant test to the facts,
yes.
which, as far as I can see, aren't desperately much in dispute.
But
So far as concerns Miss Allen, we're not concerned with the other two.
well, there is dispute about almost all of the facts as concerns Miss Allen. I think it's difficult to put it in that way of this being, as my learned friend did, as effectively all being agreed and substantive underlying facts not being in dispute. And one of the reasons it's difficult to express the full force of my client's frustration with these proceedings is that they have been on the receiving end of the inspector's report, which I will come to in terms of its process of preparation and the content of it, which made quasi-judicial findings in relation to them. That was then put before Mr. Justice Morley, without actually hearing cross-examination from Mr. Chris in relation to the disqualification issues. And the Court of Appeal then considered those matters effectively on submissions from my learned friend in relation to the evidence before it. And there is, and it's right to recognise that there is a lot of factual dispute about what is said here. And part of the difficulty for my clients has been that their opportunities to challenge some of these conclusions have been hampered by the fact that the process was started by an inspector's report which was not properly prepared, which was not undertaken in accordance with the responsibilities on that inspector, and which is unsatisfactory for the reasons that perhaps I'll now come on to.
But Miss Allen gave evidence as to why the report should not be accepted, and the judge said he was wholly unpersuaded by her evidence.
It's right that Ms. Allen did give evidence at the hearing of the disqualification proceedings, that is right. If I could just turn to the report itself, because I'd like to make a number of points about its limitations.
Just before you do, I think you sought to draw a distinction between the winding up proceedings and the disqualification proceedings,
Yes.
so far as relates to the cross-examination of the inspector.
Yes.
But the company was ultimately wound up in the public interest, wasn't it? Not because it was insolvent, am I?
It was found to be insolvent as well as it being wound up in the
But
public
it was
interest.
basically wound up in the public interest.
Yes, but that
i.e.
was...
it had been run in a way that was causing an unacceptable risk to the public. Is there really much daylight between that and the circumstances relevant to the propriety of the conduct of its directors?
I submit there was. I think the difficulty that that reliance on the report poses is that at paragraph 2.10 of the report, the inspector expressly says, he sets out a number of limitations on the report, and he expressly says that this report can only be relied on for the purposes that it was prepared. And when one goes to the term, the purpose for which it was prepared, that was the order of the court ordering an investigation into the companies.
Yeah.
So the report was not prepared for the purposes of disqualification proceedings. And I can well see that there would be similar considerations perhaps coming up in relation to the winding up, particularly on a public interest basis, and in relation to the director's disqualification proceedings. But there might also be very important matters which would be covered in a disqualification proceeding which were not addressed by the inspector. For example, the appropriateness of these respondents continuing to do business, whether directly or indirectly concerned with the management of a company, the way in which they were proposing to conduct themselves in future, the type of conduct that might be considered relevant to a disqualification test but might not be relevant to a winding up proceeding. Those are all matters in my submission which ought to have been considered when one came to the disqualification hearing, but were not, because the court proceeded on the basis of the inspector's report, which had been prepared and was expressly subject on its own terms for the purposes of the of the winding up proceedings. And we can... That is one of a number of criticisms I make of the report.
Why was it that the inspector wasn't cross-examined in the winding up in the disqualification proceedings?
I'm not entirely sure. I suspect the reason is that his report was effectively relied upon as the evidence by the registrar. And we saw that in the order that was made that we looked at earlier this morning, which effectively said that the registrar's case as regards disqualification was contained within the four corners of the inspector's report. And that was then taken as read because the inspector had already been cross-examined for the purposes of the winding up proceedings.
I mean, was there a request to cross-examine him from the respondents?
I'd need to check that. I know that there was a request to cross-examine the registrar and that was not acceded to.
Okay.
But I'm not sure off the top of my head whether formally a request was made at the hearing of disqualification proceedings. I'd like just to look at it. I don't know whether your lordships have actually turned to the inspector's report itself. It's at page 896 of the bundle onwards. I'd like to draw to the court's attention a number of paragraphs which express the limitations of that document, particularly at page 901, where the inspector draws to the attention of a reader that the report has been prepared strictly for the use by the court. Although it is understood the report will be made available to the respondents, it could only be relied on for the purposes of the matters directed in the order. That is what I've been referring to. That is the order for the disqualification, for the investigation into the companies, and not any wider use. My main...
That's just a disclaimer of reliance by third parties, isn't it?
Well, it's an important limitation. It's not just legal language in my submission, because what the inspector is doing is he is setting out the terms of what he was asked to do, which were in the terms of reference exhibited to his report. And we have those at page 958 onwards. He was asked to determine whether the businesses of the companies are being carried out by the individual respondents or any other person with an intent to defraud. And he was asked to find out what is the true ownership, shareholding and directorship of Montebacco and its affiliation of any or all respondent companies. There was no suggestion in those terms of reference that he was asked to consider the appropriateness of any of the respondents continuing to act as directors, or that he was asked to consider the terms of any disqualification order that should be made against him.
Can I just interrupt us for a moment? Just to be clear, the judge, when he made disqualification orders, based his decision on the report and on the evidence that he'd heard from the inspector on the 16th of July, 2018. That was in the winding up proceedings.
That was in the winding up proceedings, yes.
When he was cross-examined by
Yes.
Miss Allen.
He was, yes.
So it's the same, and it's the same report that we're talking about for both purposes.
Yes. One of the criticisms that the respondents have repeatedly made of the inspector's report is the degree to which it contained and indeed turned on hearsay evidence. And that attack on its admissibility was rejected as a separate ground of appeal by the Court of Appeal, so it is not before your lordships, and I don't seek to argue any argument in relation to admissibility of this report. What I do say is that the Court of Appeal was right to hold that limited weight should be given to this report, and that is a decision that I invite the Court to uphold on the merits. In particular, it is a matter of concern that the inspector appears to have attached significant weight to oral communications with third parties without any proper documentary support for the allegations advanced by those third parties, and he puts those second or third-hand communications forward as established facts in his report. This is an issue that arises particularly acutely in relation to Mr Fagan and the issue of his employment contract. Your lordships may not have picked up the detail of this point, but effectively, Mr Chris, the inspector, concluded in relation to Mr Fagan that there had been an intent to defraud, and that was a very serious conclusion that he had reached. One of the key bases for that conclusion was in relation to Mr Fagan's employment contract with the company. And if you would permit me to do so, I'd just like to take this point very briefly as to what the issue was.
Can I just understand what it goes to that we have to decide? Because as I understood it, the only issue on appeal, so far as Mr Fagan is concerned, is whether the disqualification affects him acting for anything other than these three companies.
I'm not sure that that is quite right, because I think in a world in which your lordships decided the issue of law against me, it would still be my submission that the decision of the Court of Appeal should be upheld on the merits. And I say that that is a relevant consideration because the Court of Appeal, in my submission, was deciding, when it said notwithstanding these errors as regards Mr Fagan and Ms Lidbetter, it was deciding that because of all the errors in the judge's approach, the disqualifications of those respondents should be limited to the companies under investigation. That was not only because of the issue about Section 65(2), that was reflecting the wider concerns the Court had expressed in relation to the weight of this report. Because it's difficult to read notwithstanding those errors in the plural in relation to Mr Fagan and Ms Lidbetter as anything other than encompassing all of the previous discussion in relation to weight, because otherwise it would just have referred back.
But the Court of Appeal didn't shorten their periods of disqualification.
No, but what it said was that no injustice would be carried out if the disqualification orders were limited to the companies under investigation, i.e. they were limited, the disqualification orders made against them were limited. I raised the point in relation to Mr Fagan's employment contract because it is, in my submission, one which can be readily grasped as evidencing the difficulties with this report and why it was considered by the Court of Appeal to be insufficient and to be given no weight. And that is a decision which I'm asking the Court to appeal on hold on the merits.
But the decision to be given no weight was based on the Hoyle case, wasn't it? It wasn't based on the contents of the report.
Well, it's not clear from the judgment whether it was a wider conclusion than that.
Where do we see it being a wider conclusion?
Well, I have to accept that the reference to the Hoyle report seems to imply that the Court of Appeal was proceeding on the basis that Hoyle implied an automatic finding or an automatic conclusion that in circumstances where the report did not comply with Part 32, it should be given no weight. That seems to be what they were saying. And that is not, in my submission, that is going too far in reading into Hoyle and Rogers, something which was not there.
Yeah. And also they were much impressed by the point that it didn't comply with the requirements of CPR 32 in relation to expert reports.
Yes, so that they were concerned about those requirements. They obviously refused the appeal in relation to the particular attack, saying that the report did not need to comply with those requirements. So that was one of my client's grounds of appeal at that stage. And they refused that, and they said it was a matter for weight. They then went on to say that the weight that fell to be given in view of the failure to comply with Part 32 was no weight or limited weight. And I need to be clear that I'm not seeking to suggest to the court today that it automatically follows in every case where Part 32 or the equivalent Part 35 is not complied with that a report falls to be given no weight. That in my submission would go too far, and insofar as the Court of Appeal was doing that, I do submit that was an overextension. But what I do say is that it was appropriate for a court looking at this, whether that was the first instance judge as it was initially and then the Court of Appeal, to consider the report in substance and to look at the quality of evidence that Mr. Criss was putting forward in that report and to take those matters into account when deciding whether the conclusions that the first instance judge had reached following the report were sustainable.
Well, they uphold the finding of dishonesty as far as two of the directors are concerned.
Yes. They uphold it, and I don't seek to suggest otherwise, but what they then go on to say is that there will be no miscarriage of justice if their director's disqualification is limited to the 3 companies.
And bearing in mind what they thought about the weight to be given to the report, their finding that there was dishonesty by those 2 directors must, I think one has to deduce, be mainly based on materials other than the assertions in the report.
Yes, I think that has to be the conclusion.
Yeah.
And those findings of dishonesty are concurrent findings of fact.
Yes. One of the criticisms of the report, which was advanced repeatedly below, was the failure to take an inventory in relation to the companies. And I appreciate the degree to which this court is not going to get into the underlying evidence, but it's quite a striking failure of this report, and I do want to emphasise it and take the court to it very briefly so your lordships can see the type of material that the inspector was putting forward and why it was, because the Court of Appeal was addressed in relation to this point, why this evidence was not good enough for the conclusions that it was said to support. At page 942 of the report, there's a page 942 of the bundle, paragraph 8.6 of the report, the inspector set out the assets of the company Montebacco, which is the main company under investigation, and made reference to various items of stock. And at page 943, at paragraph 8.10, the inspector recorded that he had been provided with a list of raw material, inventory, parts and machinery, and he had asked for the cost and market value. And it's important just to note in the context of the allegations of insolvency that the list that was provided by the management put the value of those items in excess of $5 million in total. The inspector goes on to say he's sceptical about that value. But at 8.12, at page 944, he says, whilst it's difficult to provide a realistic value of the inventory and machinery without spending more time and resources, my value is unlikely it was worth more than 56% of the total cost. The reason I draw this to the court's attention is that it is entirely unsupported by any documentary evidence on the part of the inspector. He has not undertaken an inventory, and that was a matter that he accepted himself when he was cross-examined on relation to solvency at the winding up hearing. At page 854, he said, I can see there's some weight to the fact that not having done an inventory count, I don't know exactly what inventory there was. The relevance of this is that insolvency was, of course, the trigger which led to the winding up proceedings. Evidently, the company's solvency or otherwise was a central issue both in those winding up proceedings, and then because it formed the basis for the conclusion of both the inspector and then the judge at first instance that these companies had been run into insolvency. It is a point that the respondents forcefully put forward in their submissions at every turn, that had a proper inventory been undertaken of these companies, it would have led to a different outcome and would have reflected a considerable value of these companies, which has simply been swept away by the inspector's failure to conduct that inventory.
Have we got the judge's judgment on the winding up petition?
Yes, I'll need to look up the reference for that, but I think we do.
I'm just currently guessing what was the main reason why he ordered the companies to be wound up, whether it really was an insolvency case or whether it was a public interest type of case.
We have the transcript of it, and we also have the transcript, I think, is at page 641.
Yes, this looks like it, the 16th of July 2018.
I'm not aware, and I'm sure my learned friend will correct me, having been involved in the underlying proceedings, I'm not aware that there is a separate judgment. I know that we have the order at 1201, is that right? 1201. Yeah, 1201 is the order, but it is not a substantive judgment. There is no reasoned judgment as far as I'm aware. And I think my learned friend confirms that in relation to the winding up that gives the reasons in any long-form way. What we have at 1201 is the recitations of the evidence that was filed, considering the context, what had happened, and so on.
Let's just read it. He sets out the evidence. Well, yes. So it's lack of records and likely insolvency is as near as you get to
Yes.
reasoning at near the bottom of page 1205.
The simple point I make in this regard is that in relation to a company whose purpose was the manufacturing and produce of tobacco products, the stock that they had and the machinery and the equipment and so on, to which management attributed a significant value of 5 million, it was a fundamental flaw in the inspector's process that he failed to conduct any proper assessment of that assertion by undertaking an inventory, by attributing a proper value to it, and by looking at the company's assets in any more detail than he did in page 942 and 943 of the bundle. That is a significant omission which really takes away the value in terms of evidential status of the inspector's report, because much of what he criticises the respondents for concerns taking large sums of money from third parties and then running the companies into insolvency. Looking then at the other side of that, the taking money from third parties, the inspector's report is also very heavily qualified, and at paragraphs 615 and 616 on page 917, he specifically says that he's not been able to verify with the people who had invested funds in the company what those funds were for, what the terms on which they had been invested for, and what the purpose of the transfers was. And insofar as he had looked into, in particular, the Andriakos brothers, he had had limited success in collecting information in that regard. That is an important limitation because the Andriakos brothers are the individuals whose share certificates were alleged to have been forfeited by my learned friend. That is, again, a factually disputed allegation. It is not one which is accepted by the respondents. Their case is that they acted at all times properly and in accordance with company law by passing a special resolution which provided for the forfeiture of the shares of those individuals in the circumstances that they did. And at its highest, Ms. Allen's evidence to the first instance judge at page 609 was that if she had made a mistake in that regard and her understanding of the effect of the steps that had been taken under the Companies Act was wrong, then that did not establish any intent to defraud and was merely a mistake. The first instance judge went on to find that she had been over-enthusiastic perhaps or led astray by Mr. Fagan but had not been dishonest, and that was an important point in terms of the overall merit of the disqualification order against her. Just in conclusion, in relation to the weight issue, I submit that the way forward through the issues that have troubled the courts in relation to this below, as to the hearsay and the status of the inspector's report, is the following. First of all, the report was admissible, and that's what the Court of Appeal found at paragraph 46. Although there are distinctions that one can draw with the English authorities involving a report prepared by the official receiver or the Secretary of State, those are matters that ultimately in my submission go to weight rather than admissibility. So I don't seek to challenge the admissibility of the report, and I accept and uphold and invite the Court to uphold the Court of Appeal's finding on that regard. The second submission I make is that the weight that was to be attributed to it was a matter in the first instance for the judge and then for the Court of Appeal below. And it was the Court of Appeal's conclusion expressed at paragraphs 66 and 67 that the judge had erred in not attributing the limited weight as he should have done, not attributing the report limited weight as he should have done.
But they do that on the basis of authority rather than on the facts. And are you seeking to uphold that decision of the Court of Appeal on the basis of that authority?
I don't seek to argue that Hoyle and Rogers gives rise to an automatic conclusion that in every case where a report does not comply with the requirements of Part 32 or Part 35, it automatically falls to be given no weight. As I said slightly earlier in my submissions, insofar as the Court of Appeal was saying that, I think that was an overstatement of the proposition in Hoyle and Rogers, and I don't seek to commend that to the Court. What I do say is that on the merits, it was right that the Court of Appeal attributed no weight to the report because of the numerous deficiencies in it. In particular, first of all, as to the process by which it was prepared, having been prepared at a very short time and for the purposes of winding up proceedings. And secondly, as to the quality of the report itself, it's very thin, it's poorly evidenced, it's not cross-referenced to documents. And on important issues, like Mr. Fagan's bona fides or his honesty, it was simply unsustainable. And I appreciate the extent to which this court is bound by the findings of fact below, so I don't seek to persuade the court in relation to upholding findings of, in relation to changing findings of fact in respect to which my clients have no permission to appeal. I recognise that I can't do that, but it is a matter that goes to weight. And just to take one very short example, one of the key reasons that the inspector found against Mr. Fagan in terms of honesty was in relation to an employment contract. He exhibits two employment contracts to his report. One of them is the one that was supplied by Mr. Fagan, which provides for his salary in exactly the sum that Mr. Fagan had said, $114,000, and your Lordships had that at page 986. The second version he exhibits to his report is said to have been provided to him by the lawyer for the Andrianakis brothers, i.e. a hostile counterparty, and it is alleged that this is a forged document, or a document which was presented by Mr. Fagan in an untruthful way, so as to give rise to a finding of dishonesty. In fact, one only needs to turn to that document at page 988 to see that it is nothing of the sort. The very document that is exhibited to this inspector's report as supposedly evidence of the serious dishonesty alleged against Mr. Fagan does not even contain a competing figure for his annual salary. One would see that at page 990, which is where the figure in relation to Mr. Fagan's salary ought to have appeared if this was going to support the conclusion that the inspector urges upon us. And actually, there is no competing figure for salary. This is simply another version which doesn't involve, which is upside down, illegible, and which is not properly cross-referenced by the inspector in his report. So much of what the inspector was saying about Mr. Fagan in relation to dishonesty is simply unsustainable on the face of the report, and it ought not to have been given any weight for that reason.
But there's no issue before us that Mr. Fagan was disqualified, ought to have been disqualified, and that the period of disqualification was 4 years.
Well, there is the order that my learned friend seeks is a restoration of the judge's order at first instance, which obviously does impose the wider disqualification rather than just the disqualification in respect of the companies. So there is, in that sense, an issue before your Lordships.
Yeah.
Unless I can assist your Lordship further, that completes my submissions.
No, thank you very much, Ms. Newton, and I would repeat just how grateful we are to you for presenting the Respondents' case. Extremely helpful.
Yeah.
Thank you. Ms. Morgan, any points you wish to come back on?
I'll first address some of the substantive points that were raised and then get to the procedural issues. No, in terms of the substantive issues in dispute between the parties, I do maintain that the underlying facts were not in dispute. Because if your lordships look at the transcripts, both of the winding up proceedings and of the disqualification proceedings, what you will see there is that there is no dispute about the basic matters that the judge found disqualification was based on. There's no dispute that there was a lease and that there was a sublease and a significant uplift. What was in contention there was the reasons for that action. And the judge had access to the leases and could see them attached to the inspector's report. And the respondents did not deny the existence of the lease or the sublease at the hearings. There was no dispute about the forfeiture of shares either. All the documents are also there, attached both to the inspector's report and submitted by the respondents in the court. So the court had access to the documents and that was being defended. So basically what we are saying when it comes to factual disputes, we have said before that the underlying facts are not in dispute, but the intentions, the reasons behind the acts, whether they can be characterized as fraudulent, and that is where the dispute generally is. There was a dispute as to insolvency, but also it was a finding of fact by the court that Montserrat was insolvent, and there was evidence there to support that finding at the issue of the winding up. And we have dealt with that issue below. In fact, there were numerous creditors, and that was also discussed below. And if we got into that, we'd have to get into the contradictory evidence of the respondents below, where they, at one point, are saying that they're unable to pay themselves salaries, and yet are saying that this company is solvent. Now, as it concerns the New Companies Act, we do think that this appeal is not necessarily academic by reason of the New Companies Act coming into existence. That's because we're still dealing with what it means to be unfit as a director. That's primarily it. And secondarily, I have noted that other jurisdictions within the region do have similar legislation, and Section 65, subsection 2 might become relevant there.
When did the new act come into force?
It came into force April 1, 2024.
Right.
So all along we have been preparing this appeal on the basis of what was formally there. But I recently became aware that it came into force, and so decided to put that in. At least in my view, there is still some relevance based on the format of the new provision. I don't think that the Court of Appeal's decision can sustain the contentions of my learned friend concerning the merits of restricting the disqualification to the three named wound-up companies. Reason being that if you look at paragraphs 80 and 81 of that decision of the Court of Appeal book, that's the only place really where the restriction of the disqualification is even discussed. It is wholly discussed with respect to the interpretation of the statute. It is not a consideration on merits of anything to do with the evidence concerning those directors. And glaringly, Section 65, subsection 2 is never discussed by the Court of Appeal. And it just seems to us that there was no consideration of that or the effect of that. We do not agree that Das and Marchand, in terms of local customs or concurrent findings of fact, would be relevant here. And that is not an authority that's relevant, because what we're concerned with are the case law and the facts that were before the court below. And even if we accept that there was a desire to encourage entrepreneurship, hand in hand with that must go a robust application of the disqualification regime, however defective it might be in itself, but there must be some kind of application of it. We do not agree that the inspector's report is defective. The inspector's report was submitted to the court with several documents attached, and those are located at pages 895 to pages 1086 of the electronic bundle. So there was a substantial amount of documentation that was submitted with the inspector's report, and the inspector also came to court and gave testimony, was cross-examined on it. All of the documents were there before the court, and concerning the most important elements which I've mentioned and which the judge also mentioned in his decision, being the lease issue and the forfeiture of shares, the documents were there. The parties could be questioned about them, and Ms. Allen was available for questioning, and she was questioned. The others chose not to be questioned. I don't know if there are any other points that concern your lordship about the substantive matter.
I don't think so.
Very well, then I will go to our response on the, I would just add this, that we did give some more guidance as to the meaning of unfitness. I think the court should advert as well to our written submissions. Those were at pages 1274 to 1282 of the electronic bundle. We do think that concerning the procedural issues, that I think it's important to say here that concerning what's happened below in the Court of Appeal, we note the respondents did say that when they go to the court to pay, they get a receipt, and that was the reason for their saying that a journal voucher in our case would not suffice. But I don't know that they're competent to speak on how government departments pay each other. The Court of Appeal did make a finding of fact in that the payment had been lodged in this particular case, and that's at page 130 of the electronic bundle. And the fact that the registrar later issued the certificate on July 6, 2022 shows that at least the registrar of the High Court was satisfied that the money had been paid as it ought to have been. We note the issue of the dispute over the record. We do have here in the supplemental bundle the affidavit that was submitted to the court when final leave was being sought. And if your lordships look at page 139 of the supplemental bundle, you will see the email record there between ourselves and the respondents in respect of the record. It begins at page 140 with an email from myself to the respondents explaining that we are progressing the appeal and we have compiled the record and we would like the comments. Now, the immediate response on June 7, 2022 was on page 139, and it was just opposition so that it did not necessarily come with any comments in terms of the record. And I don't know of any document in this bundle that speaks to comments being given on this record at this time. I will say that the documents have been hotly contested thereafter. We have had much discourse with the respondents after the denial of final leave concerning the contents of the record. But in the interval, as at this date here, we were not aware that they had those comments. I don't know if there's certain confusion concerning the disagreements that arose later. I mean, I do believe the board would be aware that we have two separate records filed in the end, so that is what happened. Those are the responses I have at this point. I don't know if your lordships have any further questions for the appellants.
No, thank you very much, Ms. Morgan. Now, we've asked you to provide us with some additional information.
Yes, you have.
Would you be able to do that within, say, 7 days?
Yes, my lord.
And if you can provide it also to Ms. Newton, if she has any observations to make, then we can receive those within, say, another week after that.
Very well, my lord.
I was actually officially on the timetable, allotted some extra time for a further response. I'm not quite sure how that was, but I just wanted to raise one point which may be of assistance to the board, which concerns other statutes in other jurisdictions.
Yes.
Because it's something that my learned friend mentioned just now in her reply. She says at paragraph 14 in the appellant's case that the interpretation of section 66(1) may impact on the jurisprudence of other Commonwealth Caribbean jurisdictions.
Yes.
And she notes provisions in various countries. I thought it might just be of assistance for the board's note if I provide the references to those and just give you a very quick summary. I think
Now, we've been doing our own homework. Shall we give you a sight of what we have, and you can see if there's anything you want to add to it?
Yes, that sounds good.
We've got a note of the provisions for, apart from Montserrat and the UK, also the Bahamas, Barbados, Trinidad and Tobago, and Jamaica.
Yes, those are the ones that I think are relevant. The point I would make is that only the Bahamas and Trinidad include the equivalent of section 65(2). So it may be that is helpful. They are... All of them include relevant, comparable provisions, but only the Bahamas and Trinidad and Tobago include the equivalent of section 65(2). So importantly, Barbados does not have that provision, and neither does Jamaica.
Yes,
Barbados includes it, isn't it?
Barbados, we think there is a...
63(2).
Yeah, section 63(2) of the Barbados Companies Act.
Okay. Yes. Thank you. Yeah.
It's Jamaica that doesn't.
Jamaica that doesn't, yes. Thank you. That was all I wanted to say, unless I can...
No, we're very grateful to you. As it happens, we had the same thought and had our judicial assistants do some research on it for us. Well, I shouldn't let the court rise without remarking that it's a very welcome change to have 3 women counsel addressing us in a company's matter. I think that's a first. Well, you've given us quite a bit to think about. We'll go off and reflect on what you've said to us, and we'll then decide what advice we will tender to His Majesty. In the meantime, the court will adjourn.